The Senate will come to order. Senators, be in your chairs. The clerk will call the roll.
Alley. Baumgardner. Billinger. Bowers. Clays. Corson. Dietrich. Dahl. Erickson. Estes. Fagg. Faust-Godot. Francisco. Gossage. Haley. Hawk. Hildebrand. Holland. Holscher. Kirshen. Cluse. Longbine. Masterson. McGinn. Olson. O'Shea. Heck. Peterson. Petty. Pittman. Pyle. Steffen. Straub. Solentrop. Sykes. Thompson. Tyson. Ware. Warren. Wilborn.
Here. Senators and your guests, please rise and give prayerful attention to the chaplain.
Please join with me in prayer. Heavenly Father, in the United States Capitol, here in Kansas and in capitals all across this land, there are new individuals taking oaths to serve under your divine authority. We find in Romans 13, verse 1, that it is by your divine providence that each of these positions is filled. And in 1 Timothy chapter 1, verses 1 through 4, you tell us to pray for our leaders so that we may live peaceful, quiet lives, lives that reflect a calm, godly dignity. And you give us this very critical directive in 1 Thessalonians chapter 5, verse 17. You tell us to pray without ceasing. But Lord, with all of the unrest that we see, it seems that we're not praying enough, or maybe there's not enough of us praying. Lord, you call us to pray because the reconciling of differences, the ending of hostilities begins with you. It starts at the top. So, Lord, we look to you. We appeal to you. Give us the wisdom and the guidance to reject ways that injure and to hold tightly to ways that are godly. We're trusting you, Lord, to take us to that place of peace. I bring this humble request to you in the precious name of Jesus. Amen.
Please continue standing for the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Messages from the House, the clerk will read.
Announcing passage of Senate Bill 14.
Before recessing, are there any announcements? Seeing none, the chair recognizes Majority Leader from Sedgwick, Senator Schellentrop.
Thank you, Mr. Vice President. I move that the Senate recess to the sound of the gavel.
You've heard the Senator, do you wish to announce a caucus meeting?
Senate Republicans will meet in our normal caucus room on 5th floor after we gavel out.
Senator from Douglas, Francisco.
Thank you, Mr. Vice President. The Senate Democrats will caucus in room 287 North upon recess.
Back to the motion. You've heard the motion from the Senate Majority Leader. All those in favor say aye. Opposed, no. The motion carries.
Senate will come to order. I think we have an announcement real quick. Senator from Douglas, Senator Holland, you have an announcement?
Thank you, Senate President. I'll be very brief. Fellow senators, I'm reintroducing my Golden Years Homestead Property Tax Freeze program. It had some interest on both sides of the aisle last year. If you'd like to sign on and be a co-sponsor, come by and see me today. Thank you, Mr. President.
You bet. There's my clerk. All right. Reports of standing committees, clerk will read.
Mr. President, the Committee on Agriculture and Natural Resources recommends Senate Bill 27 be passed. Senator Kirshen, chairperson. Mr. President, your Committee on Judiciary begs leave to submit the following report. The following appointment was referred to and considered by the committee, and your committee recommends that the Senate approve and consent to such appointment by the Governor, Judge, Court of Appeals, Amy Klein, Kelly Warren, chairperson. Mr. President, your Committee on Judiciary begs leave to submit the following report. The following appointment was referred to and considered by the committee, and your committee reports without recommendation to the Senate such appointment by the Governor, Judge, Court of Appeals, Carl Folsom III, Kelly Warren, chairperson.
Consideration of appointments. The chair recognizes the majority leader from Sedgwick, Senator Solentrop.
Thank you, Mr. President. In compliance with Senate Rule 55, the appointment of pages 1 through 3 of the calendar are ready for consideration. Are there any questions?
Questions on those appointments? Seeing none, Senator Solentrop.
Thank you. I move the appointments be confirmed as recommended by the Committee on Confirmation Oversight.
We will hold for final action. We are now ready for final action. On the first roll call, we will take the appointments on page 1 and the first 7 appointments on page 2. Hurt, Samaniago, Height, Jacobs, Yoder, Poling, French, Watson, LaRue, and Broomgard. Clerk will read the names.
Credit Union Administrator, Vicki Hurt. Crime Victims Compensation Board, Richard Samaniago, Stuart Stu Height. Employment Security Board of Review, Valerie Jacobs. Kansas Air National Guard Commander, Colonel Chris Yoder. Kansas Board of Healing Arts Executive Director, Tucker Poling. Kansas Corporation Commission, Commissioner Andrew French. Kansas Human Rights Commission, Industry Representative Crystal Watson. Kansas Lottery Commission, Margaret LaRue, Pete Brungart.
The clerk will call the roll.
Alley. Baumgardner. Billinger. Bowers. Clays. Corson. Dietrich. Dahl. Erickson. Estes. Fagg. Pascadeau. Francisco. Gossage. Haley. Hawk. Hildebrand. Holland. Bolsher. Kirshen. Cluse. Longbine. Masterson. McGinn. Olson. O'Shea. Peck. Peterson. Petty. Pittman. Pyle. Steffen. Straub. Solentrop. Sykes. Thompson. Tyson. Ware. Warren. Wilborn.
Has everyone had an opportunity to vote? Senator from Sedgwick, Senator McGinn. We're going to pause for just a second because we should have at least 2 more that we know are in the building. We'll pause, stand at ease for just a second. Since these are just confirmations and appears to be unanimous, I'm going to go ahead and close the roll, tally the vote. Does anyone wish to explain their vote? Does anyone wish to change their vote? Seeing none. "36 having voted in favor and none against the entire list, they're hereby declared confirmed." I love that gavel. Hardly have to swing it. All right, second roll call. We will take the remaining appointments on page 2. Zakura, Moses, Turnquist, Owen, McKinney, Thomas, Brown, and Wright. Clerk will read the names.
Kansas Public Employees Retirement System Board of Trustees, James Zakura. Kansas Racing and Gaming Commission, David Moses, Larry Turnquist. Kansas Water Office Director, Constance Owen. Pooled Money Investment Board, Dennis McKinney, Tracy Thomas. State Board of Tax Appeals, Chief Hearings Officer, Thomas Brown. State Civil Service Board, Thomas Wright.
Clerk will call the roll.
Alley, Baumgardner, Billinger, Bowers, Clays, Corson, Dietrich, Dahl, Erickson, Estes, Fag, Fauskido, Francisco, Gossage, Haley, Hawk, Hildebrand, Holland, Fulcher, Kirshen, Cluse, Longbine, Masterson, McGinn, Olson, O'Shea, Heck, Peterson, Petty, Pittman, Heil, Steffen, Straub, Solentrop, Sykes, Thompson, Heisen, Ware, Warren, Wilborn.
Has every senator had an opportunity to vote? Does any senator wish to change their vote? Any senator wish to explain their vote? Seeing none, clerk will close the roll, tally the vote. "37 in favor and 0 against Moses, Turnquist, Owen, McKinney, Thomas, Brown, and Wright. 36 in favor and 1 opposed to Zakura. These appointments, having received their constitutional majority, are hereby declared confirmed." On the third roll call, we'll take the appointments on page 3. Barry, Mitchell, Tatum Haskell, Wolf, Kaufman, Graves, Kahn, King, Mahoney, and Moran. Clerk will read the names.
State Banking Board, Mary Berry, Irvin Mitchell, Leah Tatum Haskell, Leonard Wolf. University of Kansas Hospital Authority, Monty Kaufman, Gregory Graves, Dr. Talal W. Khan, Elizabeth H. King, Maureen Mahoney, Rabba Moran.
Clerk will call the roll.
Alley, Baumgardner, Billinger, Bowers, Clays, Corson, Dietrich, Dahl, Erickson, Estes, Fag, Faust-Godot, Francisco, Gossage, Haley, Hawk, Hildebrand, Holland, Olsher, Kirshen, Cluse, Longbine, Masterson, McGinn, Olson, O'Shea, Heck, Peterson, Petty, Pittman, Heil, Steffen, Straub, Solentrop, Sykes, Thompson, Tyson, Ware, Warren, Wilborn.
Has every senator had an opportunity to vote? Does anyone wish to explain their vote? Does anyone wish to change their vote? Seeing none, the clerk will close the roll, tally the vote. Thirty-seven having voted in favor and none against, the entire list on page 3. These appointments, having received their constitutional majority, are hereby declared confirmed. Consideration of appointments. The chair recognizes the majority leader from Sedgwick, Senator Solentrop.
Thank you, Mr. President. The appointment of Carl Folsom to the Kansas Court of Appeals is ready for consideration. Are there any questions?
Questions for the senator from Sedgwick? I want to look you up, man. You're Johnson, right? Senator from Johnson, Senator Corson.
Thank you, Mr. President. I do not have a question, but I would like to speak in support of the nomination of Carl Folsom to the Kansas Court of Appeals. As this body considers Mr. Folsom's nomination, there are a few points I would like to emphasize. The first is that any concern that Mr. Folsom would be an activist judge is misplaced. I say this not because it is my own view, but because our state's leading judicial conservatives have told us that Mr. Folsom would not be an activist judge, which is why they strongly support his nomination. Stephen McAllister, who served our state with distinction as Dean of the Law School at the University of Kansas, as Kansas's Solicitor General under Derek Schmidt, and is the U.S. Attorney for Kansas, appointed by President Trump, where he is our state's chief federal prosecutor, wrote to the Judiciary Committee that, having known Mr. Folsom since Mr. Folsom was an undergraduate student at KU, all the way through being opposing counsel in a case with Mr. Folsom as our U.S. Attorney, that Mr. Folsom, quote, will approach judging with humility and modesty. That he, quote, will not be driven by an agenda, nor will he, quote, be political as a judge. Instead, he wrote that Mr. Folsom, quote, will simply be an excellent, careful, and thoughtful judge. And that he, quote, has complete faith in Mr. Folsom's abilities, integrity, and fairness. Mr. McAllister concludes by stating his, quote, enthusiastic and unqualified personal support for Mr. Folsom's nomination. Senator Jeff King, an accomplished judicial conservative and appellate attorney who served with distinction as Senate Vice President and as chair of the Senate Judiciary Committee, wrote to the Judiciary Committee that Mr. Folsom, quote, would be an excellent addition to the Kansas Court of Appeals, and, quote, because he is a, quote, skilled writer, a talented legal scholar, and an effective communicator. Indeed, Senator King notes that, quote, all of the appellate judges he has encountered clearly respected Mr. Folsom's diligence, work ethic, and legal acumen. At this morning's hearing, I asked Senator King directly if he thought Mr. Folsom would be an activist judge, and he said point blank, no. And that if he thought Mr. Folsom would be an activist judge, he would not be so strongly supporting him. Instead, Senator King stated that based on his professional knowledge of Mr. Folsom, which spans more than a decade, he has, quote, seen nothing that would indicate anything but a strict adherence to legal interpretation and judicial restraint. The second point I want to make is that Mr. Folsom is extremely well qualified, and his extensive criminal and appellate experience would make the court more well-rounded. Approximately 75 to 80% of the cases heard by the Court of Appeals are criminal cases. Yet more than half of the judges currently on the Court of Appeals had no criminal experience before joining the bench, and the few that did were either former prosecutors or county attorneys. Mr. Folsom would bring with him to the bench the experience of having litigated almost 200 appeals, having argued 21 times before the Kansas Supreme Court, 46 times before the Kansas Court of Appeals, and 11 times before the U.S. Court of Appeals for the 10th Circuit, a level of appellate experience that simply dwarfs that brought to the bench by any current member of the Court of Appeals. Keep in mind, the court hears cases in 3-judge panels. So even if there's a question about the range of Mr. Folsom's experience, that experience will always be complemented by that of the 2 other judges. Ultimately, our goal should be that the 14-person court be made up of lawyers with a range of experience, but not that each judge, him or herself, possess the full range of experiences, because no nominee could meet that standard. The third point is that it would be deeply unfair to Mr. Folsom, but more importantly, to this process, for this body to decide that Mr. Folsom's experience as a public defender somehow makes him unfit to be a judge. Perhaps the best perspective on this issue was rendered by Justice Caleb Stegall in his June 9th, 2020 op-ed in the Topeka Capital Journal. Justice Stegall wrote that it would be, quote, unfair to the nominee, and, quote, to attack him for having represented criminal defendants. And that doing so, quote, belies either a real ignorance of our system of justice or a cynical exploitation of that ignorance. Because, as Justice Stegall noted, quote, in a court of law, every person must be heard. In criminal cases, their cause must be represented by competent and trained counsel. Everyone is equal before the bar of justice, and no one, no matter how despised they may be by society, is prejudged or presumed guilty. It is worth recalling the words of Michael Hoflish, the former dean of the University of Kansas School of Law, who wrote that, quote, one of the fundamental underpinnings of the American justice system is that every litigant is entitled to legal representation. Lawyers often take on unpopular clients. It is simply wrong to suggest that a lawyer is unfit to be a judge because one does not like his clients. That statement, written in defense of Justice Stegall when he was nominated to the Court of Appeals in 2013, was true then, and it is true today. So where does all of this leave us? The record is clear. Based on the strong support he has received from our state's leading judicial conservatives, Mr. Folsom would not be an activist judge. It is also clear that Mr. Folsom is exceptionally well qualified to be on the Court of Appeals, having litigated nearly 200 appeals and conducted 46 oral arguments before the Court of Appeals. And his criminal experience would help fill a gap that currently exists on the court. Finally, we know that it would be both wrong and set a dangerous precedent for this body to reject a judicial nominee based on who that nominee has represented. That is why this body should rise to the occasion. We should prove to Kansans at the dawn of this new legislative session that we can indeed work together to do the people's business, and we should confirm this well-qualified nominee to the Court of Appeals so that court can have a full bench and timely resolve the cases that come before it. Thank you, Mr. President.
Further question or comment? I would say, just point of housekeeping, since this is some of our original debates, and actually, Senator from Johnson, you did pretty good. I violated this rule all the time myself when I was in the front row. You are addressing, and this isn't just to the Senator from Johnson. When you address, you're addressing the chair for decorum. Be careful about turning around and facing back into, even though it feels like that's the natural thing to do. I thought you did. I got called down for it all the time. It just reminded me of it. So just wanted to make that reminder clear on that. And since we're outside of the committee of the whole, this is a speak twice. I meant to do this before, so I apologize about breaking this. You can speak twice with the exception of the carrier of the motion, which is at this point the majority leader and the chair of the committee that had the confirmation. So they are exceptions to that twice, just FYI. Back on our business. Apologize for that public service announcement. Senator for Cherokee, Senator Hildebrand.
Thank you, Mr. President. As the holdovers from the Senate that are sitting in this chamber that were here on June 3rd, 2020, heard me get up and read a series of an email exchange I had with Mr. Folsom. It's quite lengthy. I really don't want to reread it again, but just to give you some highlights, and then I'll talk a little bit more about my recent discussion with him. He did come and I did get a chance to talk to him. I would say, very nice guy, very likable guy, somebody that you could have a picnic with, I believe. But as a Senate and as a body, we are not here because somebody's a nice guy. We are tasked with confirming or non-confirming a judicial nominee for the appellate court, something that we should not take lightly at all. And that's something I don't take lightly, and I take very seriously. And one of the things that I do take very seriously is our Constitution, our U.S. Constitution and our state Constitution. Last Monday, every single person sitting in this chamber, staff included, they might not have taken it Monday, they might have taken it earlier, but took an oath of office to uphold the Kansas and U.S. Constitution. So, putting that in perspective, I'll read you the questions that I had of Mr. Folsom after his June 2nd confirmation hearing back originally, and then I will just kind of highlight some of the points. My first question to him was, you had mentioned a few times that the judicial branch could change the laws, but they had to do it slowly as not to disrupt the current law. I would like to hear your opinion on how this is accomplished, as well as give an example to this process. Mr. Folsom responded that a judge would have to do it over time, that it's something that you couldn't just do instantaneously because of businesses and people do count on opinions that the court gives, hands out. Stare decisis is a term that, not being in the legal field, I had the privilege of finding out what that meant for sure. I heard it a few times when I was hearing confirmation hearings, but stare decisis is going, I guess, against the precedents of the Supreme Court or another precedent that another judge has given. So he put a lot in the original question or response on June 3rd that a judge could change the law. But they had to do it over time and had to be conscious of the effects of what changing that would be. He did give me a follow-up after he had a little bit of time to think about this, and this was, I believe it was a week ago from today. He told me that, in general, the legislature writes the laws, the executive branch enforces the laws, and the judicial branch interprets the laws. One thing should be clear, the judicial branch cannot change the law. So he went on to explain that in his belief, an opinion issued by a judge would be case law, and that was the law that he was referring to when he said that a judge could change the law. My second question, you said that the Constitution was the supreme law of the land. However, if the Supreme Court issues an opinion that is contrary to the plain language of that supreme law, you would be bound to follow the errant Supreme Court's precedents. Can you explain in detail how the supreme law of the land can be superseded by an opinion? In short, he didn't feel that they could because Supreme Court precedent was supreme to the U.S. Constitution and the state Constitution, because he believes, that was his initial response. In his follow-up last week, he expounded on it a little bit and said that because he believes that it is following the Constitution, because in Section 3 of the Constitution it says that the Kansas Supreme Court has jurisdiction, that there dictates to any court below that they are not free to interpret the Constitution or to rule by the Constitution, that they have to rule by Supreme Court precedents. My third question was kind of a follow-up to my second question, and there were two parts. You referenced Marbury versus Madison as one of the most important opinions issued by the U.S. Supreme Court. The reason given was because of the first time it gave the judicial branch the opportunity to have checks and balances on the legislative and executive branches. If there are indeed three equal branches of government, what are the checks and balances that executive and legislative branches have on the judicial branch? And when do you feel it is appropriate to use those checks and balances? It was a pretty short answer, so I'll go ahead and read it. This is on June 3rd. The legislature can amend a statute if it disagrees with the way the court interprets it. The executive can appeal the Kansas court to a higher court, or it can request the legislature change the law. And in his follow-up, he just kind of expanded on that a little bit. Nothing really changed on that. But he did add that the ultimate check on the power of the executive branch was their retention election. The second part of that question on June 3rd was the following up to question 2. In the case of Marbury versus Madison, Chief Justice Marshall issued this statement: "A law repugnant to the Constitution is void." This appears to be setting the precedence that nothing supersedes the supreme law of the land, not even another Supreme Court's opinion. Do you view this as being a direct conflict for you to be bound to the Kansas Supreme Court's opinion rather than the Kansas and U.S. Constitution? On June 3rd, his answer was the answer to question 2. On last week, I'll go ahead and read it since I'm almost through, if you guys will indulge me. There is no dispute that a law repugnant to the Constitution is void. If an opinion of the Kansas Supreme Court is in conflict with the Kansas Constitution or U.S. Constitution, it should be overturned. But the role of a Court of Appeals judge is very limited. For each case, there is a 3-judge panel assigned to the appeal. For statutory issues, the Court of Appeals panel just applies the statutes written by the legislature to the facts of the case. For constitutional issues, the court panel applies the text of the Constitution to the given legal issues. But for any type of legal issue, the Court of Appeals cannot overturn a decision of the Kansas Supreme Court that is squarely on point. As Justice Amy Coney Barrett said of the 7th Circuit Court of Appeals during her confirmation hearing, "I can't buck the Supreme Court. Just a little note, she is a federal judge." In 2014, when he was on the Court of Appeals, then Judge Caleb Stegall ruled on a constitutional issue by concluding that the Kansas Supreme Court had made a decision on the issue in State v. Marshall. Then Judge Stegall wrote, "This court is duty-bound to follow Kansas Supreme Court precedent, absent some indication that the court is departing from its previous position." There is no dispute about this concept of vertical stare decisis in the legal community. Court of Appeals judges have to follow the decisions of the Kansas Supreme Court. The approach is warranted by the Kansas Constitution. Under the Kansas Constitution, the Kansas Supreme Court has general authority over the other courts of the state. This means that the lower courts have to follow the decisions of the Kansas Supreme Court. And that was our correspondence. We had a good talk, I thought. We didn't agree wholly on constitutional things, or actually the Supreme Court having precedence over our state constitution or our U.S. Constitution. The thing that bugs me about this is we are a legislative body sitting here. As legislators, we pass laws. It takes it from this chamber over to the House, another legislative body. They then can adopt the same law that we did or amend it. There's a process, and then it goes to the governor to be signed. So if we're going to refer to laws, and there are supposed to be 3 distinct branches of government, the judicial branch does not have the authority to pass laws, only the legislative body. And then the executive body has the opportunity to sign that law or that bill into law. And then they are responsible for executing that law. So if that is indeed the case law should not override a constitution or our statutes. And if the Supreme Court has precedence over the U.S. and state constitution, why do we expect anybody in the judicial branch to take an oath to defend our Constitution, U.S. Constitution and state constitution? Why does that oath not say to be bound to defend the Supreme Court's precedents? With that, as a body, it is difficult, especially when you get to meet someone, and he seems like a really nice guy, and it makes it difficult for a decision like this. But like I said earlier, we're not here to decide who's the nicest guy. We're here to do our job that we were elected to do. And because of that, and because of my strong beliefs that the Constitution, U.S. Constitution and the state Constitution are indeed the supreme law of the land, not our Supreme Court, I will be voting no. Thank you.
Further questions for the Majority Leader? Senator from Leavenworth, Senator Pittman.
Thank you, Mr. President. As I stand in support of this appointee, this multi-generational Kansan, I think of him as someone who's from Leavenworth County, my home county, and I think of his experience, not just that he's a great guy who I'd be glad to have a picnic with, but somebody who has a great deal of experience in what we're asking him to do. I think that when we look at his answers to those very deep questions the senator from Cherokee asked, and I commend the senator for going down that line, it shows that Mr. Folsom has a command of understanding how laws proceed through our judicial system. It shows that he understands that judges could be activist judges, but just understanding that does not mean that he is the type of judge that one doesn't want necessarily if one has that opinion of not liking activist judges. I think of his work as a public defender. I think of the vast number of cases I've been told, 75% is the stat I've been quoted, of cases that go to the Court of Appeals involve some kind of criminal case. And yet, the Court of Appeals in Kansas doesn't have that experience of a public defender in its ranks to the degree it does other types of lawyers. Mr. Folsom brings that public defender experience, that notion of what it means to be the single mother who gets in trouble with crimes, the veteran he helped save, who was defending somebody with his firearm, and who he then went to defend in a case to get that case overturned. That he understands that he's fighting for those constitutional rights of people who often don't have a lot of money to bring to the courts. When I served in the House, I was on the Public Safety Committee, and we heard the dollar amounts, the woeful amounts we spend to help with public defense and the troubles we have in that department. And unless you're in there, you don't understand how a lot of folks get themselves into these situations and their predicaments. And we need, in this time when we've been hearing the need for criminal justice reform in our country, when we hear about the people who are in these courts who need a voice or at least a recognition of their plight, I don't feel it's appropriate to tell this person that has this experience in public defense, who's well qualified, who hasn't shown activist judge tendencies, to say, no, I think it's appropriate that we go ahead and vote yes on this, and I will be in support of this appointment.
Further question or comment for the Majority Leader? Senator from Johnson, Senator Sykes.
I think the other senator from Johnson, Senator Thompson, was standing. If he wants to go first.
You have the floor now. Yeah, thank you.
Thank you. I don't have a question, just a couple of comments. You know, I know many of you do not agree with our governor on policy, and I understand voting on appointments by governors with whom you disagree. When I was a freshman senator and was presented with appointments to consider, I was skeptical that the reasoning behind their nominations would be anything other than continued partisan games. The night before voting on appointments, I called a long-serving, well-respected, bipartisan senator from the other side of the aisle to seek her advice. Though she was no fan of Governor Brownback herself, the senator recommended that I set aside my frustrations with the administration's policies in my approach to these nominations. Senator Laura Kelly urged me to look at these candidates' qualifications and recommendations by the peers before I made my decision. Last week, I shared some of my proudest moments as a member of this body, and I ask us all to put forth the best versions of ourselves as we approach the work ahead. Today, I would like to share one of my most disappointing and shameful moments that I've experienced as a senator. Last June, we voted not to confirm an extremely qualified, highly recommended appointment to the Kansas Court of Appeals. We played political games with the Kansas courts and with Carl Folsom's career. Since then, we have learned how wrong we were in making that decision. After that vote, articles and editorials appeared in the Kansas City Star, the Topeka Capital Journal, the Kansas Reflector, emails and phone calls from Kansas across the political spectrum who were shocked at this body's short-sightedness and prejudice. Kansas district attorneys and conservative Kansas Supreme Court justice and the Kansas Bar Association called our decision unfair, irresponsible, and just plain wrong. And since then, some of Kansas' top legal experts have come out in support of Mr. Folsom's nomination to another Court of Appeals seat. Scores of his peers have signed a letter recommending his appointment, and letters from U.S. Attorney Steve McAllister, former Senate Vice President Jeff King, endorse Mr. Folsom for his temperament, jurisprudence, and experience. Mr. Folsom is clearly qualified to be confirmed to the bench. Today, I urge the body to right the wrong that we made in June and confirm Carl Folsom to the Kansas Court of Appeals. Set aside the partisan games and consider Mr. Folsom's qualifications and the recommendations of his peers. Our courts and Carl Folsom's career depend on it. Thank you, Mr. President.
Further question or comment? Senator from Johnson, Senator Thompson.
Thank you, Mr. President. 3 quick points. I was on the original hearing of Mr. Folsom back 7 months ago, and on this one as well. There were some troubling remarks that he made, one with regard to haste. He used the term haste, or that I hastily replied to comments and then came back and used that as justification for making those comments and then corrected himself. I don't think that haste is a good justification for somebody who is looking to become someone who makes decisions, that has to deliberate over those decisions, and that points to some concern about whether or not he'll deliberate over the decisions he's faced with in that position. With regard to the breadth and depth of his experience, in the committee today, one answer was when questioned about the limited scope of his experience, he said, well, I will be, to paraphrase, along with other two other judges who will have that experience and who I can rely on for information, lean on, essentially. I think that if we're going to confirm a judge, we want someone who already has the experience to make an independent decision on his own without having to rely on someone else. Someone who doesn't have that experience is going to be easily persuaded to vote one way or another, or to rule one way or another. And in the private sector, we don't take someone, in my previous career, we didn't throw someone without the experience to make some value judgments into the deep end of the pool right away. We allowed them to gain the experience they needed, because when you're confronted with a number of different situations, you need to be able to handle them well, and that was troubling. And then with regard to the activism, we heard, of course, from a number of his colleagues who said that they weren't concerned with that. However, after our denial of his confirmation the first time around, I was thanked by several of his former students who confirmed my suspicion that he would be an activist judge. They had set in on the classes. They were concerned with what they heard in class and felt he would be an activist judge. So that runs contrary to what we've heard from testimony in committee. We didn't hear anyone express that, but I did want to pass that along to the body for consideration. And to Senator from Cherokee's, Senator Hildebrand's point, I too was concerned over some of his answers regarding whether or not he would look to the Constitution for guidance in his decisions. So those three quick points lead me to be consistent with my previous vote, that along with the fact that I don't think he has the breadth and depth of knowledge to make the judge at this point. I wish that he would have waited longer so he could have gained that experience. This is not an indictment of the job he does as a public defender. Obviously, we need his expertise there, but this is more on the order of the lack of experience and these three other concerns I have that make me consistent with my previous vote of no on the appointee. Thank you, Mr. Chair.
Further question or comment for the Majority Leader? Senator from Wyandotte, Senator Haley.
I don't think this is this on? I haven't spoken much in it this year, Mr. President, and really didn't know that I was going to speak to this nomination that's before us at all, but I thought I needed to, Mr. President, addressing you and certainly our members. I just want you to know, Mr. President, what I hope that most of us in here really take under consideration. And in my 20 years of sitting on our Judiciary Committee in different capacities, I've heard a couple of nominees come before us, many of whom are now positioned on our courts that have come through the vetting process where their peers, those who are stakeholders in the law, have the pros and cons of their background, that we then take that nominee and have that vetting process among ourselves on the Judiciary Committee. And I dare say that I've ever seen or heard a more qualified, in my 20 years on the judiciary, more qualified nominee to come before this body than Carl Folsom. And I don't say that lightly. I'm not taking anything away from some of the now current jurists that we have. Many of them, those men and those women, had an array or background that would allow them to be seated there, and indeed they're there and doing a good job. But I certainly want to say that when it comes to experience, that there's no greater experience that I've seen or that I've heard as a member of the Senate Judiciary Committee. There's no broader array of those who practice in the field, be they anywhere on the political diaspora, considered conservative or liberal or everywhere in between, who've spoken of his prowess, his ability, his temerity, his knowledge of the law, his ability to make us proud as Kansans for the quality that we would have. Mr. President, I'm sitting here and I got a little confused. I hadn't planned to speak. Really, I'm glad to sit on the judiciary. I heard the pros and cons coming out, but I just want you to know, if nothing else, I want the members to know that are here, this is probably the best nominee that during your tenure, our tenure here, Mr. President, I'm sorry, that you're ever going to get a chance to vote on to confirm. They have not come any better, and I don't care whether he's a nice guy or not, as has been said, you know. This nice guy should not finish last. This should be a nominee that we would all be proud of. Finally, let me just say that, you know, during this process last year and what happened afterwards and the fallout that has been referenced from all across the state, that Carl Folsom had not been confirmed. If one practices in different fields, whatever that is, as defense counsel, and it has been said and it bears repeating, we don't have that balance of diversity on our appellate court. We should have different people who have practiced in different means and different fields on our court. Doesn't that make any sense, or shouldn't that make sense, I would hope, to everyone? Carl Folsom has served exceptionally well. He's more experienced and more qualified, according to his peers and the stakeholders, in a well-vetted process that brought him, as we know, not once, but now twice, imagine that, before us. Mr. President, I don't know, I know you're not, but I know you're able to articulate to yourself why you would or would not support Mr. Folsom, but there probably are some people here that aren't really quite sure why exactly the best, most qualified of a particular nominee is not a, if you'll pardon the sports metaphor, a slam dunk to be affirmed. And I just ask each of us to say to yourself that if you can't articulate for yourself why the most qualified should not be affirmed, then vote to affirm him. I believe he is not going to be an activist judge. That's one of the things. I think that his experience as a law professor and what he does in a courtroom can be exceedingly different, or will be different, as has been alleged. The two are not related. And finally, let me say that, you know, I look to professionals. When I hire a professional for a specific job, whatever that job might be, if I'm gonna have somebody come work on my house or on my car, or if I'm gonna have someone to represent a field that I'm not competent in court or anywhere else, I listen very carefully to those who know the skill set of someone who is going to perform that task for me. I want someone else's judgment to help me, especially if there's an array of judgment, to help me to come to the conclusion of who should handle the job. If that's the case that's consistent, if that's the continuity of reference that we would rely on in our personal lives, we should rely on that same reference today. As Carl Folsom comes very highly recommended, I have not heard, and I've listened very carefully, or seen a better qualified candidate to serve, and I hope that each of us will be voting to affirm his nomination today, Mr. President. Thank you.
Further question or comment? Senator from Wyandotte, Senator Petty.
Thank you, Mr. President. I think we've had a lot of information provided, not for those of us that were here last session and now this session, about Mr. Folsom. And for all of us that have had the opportunity to visit with him, to learn that he's a man of strong character, and I've had the opportunity, as some of you had, to have other appointments before us, and we haven't always had someone with as much depth of experience when, in this case, over 15 years. I find that to be a reasonable amount of time to know that somebody's been practicing law and been working in not only in front of the courts, but also teaching as well. We've heard some information about projecting possibly that he has an opinion that the courts can work outside of the law. And I've always felt we have 3 branches of government, and so the judiciary is such an important branch to help to allow our citizens to have judgments before the courts, but they are dependent on what we have in statute. And I think it's important to understand that Mr. Folsom said that the courts cannot change the language of a statute passed by the legislature, and they cannot change the Constitution. So he knows what the courts are working within and the parameters that they're working within. We know here as a branch ourselves that how a bill is written is very important. Earlier, one of my colleagues here on the floor mentioned about the fact that, you know, there's legislation that's passed on this side of the rotunda, then that goes over to the House, and legislation's passed out over there. And often we find out that how it was interpreted within committee on this side, it's not looked at in the same way. Within the courts, that's why it's so important that legislation is clear. And that's why at times that legislation comes back to us to be reworked, to be improved. And we know, some of you sit on those oversight committees, we know that our legislation, particularly with the courts, is looked at it and brought forward for changes every single time that we're here on the floor. So I think it's important to remember that, to realize that Mr. Folsom did not say in his discussions that the courts he is above the law, but that he did explain that the courts cannot change the language of a statute passed by the legislature, and that cannot change the Constitution. So he would be, and has in his practice, worked within the confines of our Kansas law. I think it's important to realize that, and I stand in support of his appointment to the Court of Appeals.
Further question or comment on the Folsom appointment? Senator from Johnson, Senator Warren.
Thank you, Mr. President. Nominees for Kansas Court of Appeals who come before this body to be considered for confirmation have many kinds of legal experience. So when a nominee is considered by this body, we have the obligation to look at that experience and to know that when the experience is limited to a narrow area of the law, it's not surprising that then it raises a lot of questions and concerns. I'd like to address a couple of points that were made today. Having had the honor of conducting the hearing today and congratulated Mr. Folsom for making it this far in the process and for his appearance today. It's been suggested that this legislative body doesn't recognize that a lawyer isn't his client, and a lawyer represents all kinds of different clients. So this legislative body knows the difference between the lawyer and a client, and that the Constitution provides that in criminal matters, when a defendant can't afford an attorney, one will be appointed, and no one is holding that against the nominee. It's been also suggested that this body act today to correct or right a past wrong. I want the body to know that today in committee, Mr. Folsom was asked whether he thought the legislative process, the hearing process last summer, I was not a part of it, I was not a member of the Senate at the time. He was asked to state whether he thought the process was fair. He repeated many times, yes, he felt the process was fair. So I would submit there's no wrong to right here today. It was merely the decision of the deliberations of this body last summer, and the process worked as intended. It's also been suggested that this body should worry about the career of the nominee. And I would submit that it's not the proper place of this legislative body to deliberate about the career implications of an affirmation of the nomination or voting it down. We have to look at the breadth and depth of experience of the nominees who come before this body. The responses provided by Mr. Folsom give us insight to that breadth and depth. His resume gives us insight to that breadth and depth. So while he may have depth in his area of practice, which we would want expertise in the certain areas of law that a lawyer endeavors to practice. We also, on the Court of Appeals, though, need breadth. And it doesn't seem that the nominee has the required or qualifying breadth of legal experience that we would ultimately want on the Court of Appeals. It's been also suggested that as members of this body, we look at our peers and what their recommendations are regarding the nominee. Well, this body, a mere 7-ish months ago, voted on this particular nominee. So this body, peers in this chamber, have voted on this nominee. And that's not to be taken lightly. What has changed between 7 months ago and today regarding this particular nominee? And it would be, I would submit, because we asked him in committee today, it was asked of him, what has changed? And it would be, by paraphrasing his own answer, he has more letters of recommendation to support his nomination. Well, that's not really increasing your qualifications for the Court of Appeals. So we need to look at his actual, any nominee's qualifications rather than just letters of recommendation, because when we are giving the authority to the Court of Appeals to make decisions, it's not those recommendations that are going to be making the decisions. It's going to be the actual judge sitting on the bench. It's also been suggested that our belief that he will or won't be an activist judge on the court is important. And actually, this body's belief about whether a particular nominee will be an activist judge or not doesn't, I would submit, weigh in all that much, because we can look at the nominee's own statements. And we've heard statements from the nominee in June 2020 that you can't change the law too fast in the courts. You have to do it gradually. And that causes concern because, as we've heard and as we know, we have 3 different branches of government, and it's not the judicial branch that writes the laws. It's been suggested that this is possibly the most qualified nominee in the last 20 years to come before the Senate Judiciary Committee. I would point out that I believe in 2019, the governor had the opportunities to select Mr. Folsom as a district court judge, but didn't select him for the lower court position, and now this body is deliberating and determining whether to appoint him to a higher level court position. And we can only surmise that perhaps the choice to not appoint him for a district court judge position was because there was a candidate with better experience and credentials. So the nominee has received a fair hearing, and we've gone through the legislative process of deliberation, and I thank the body's time and attention and the work of the committee, and I stand for any questions.
Further question or comment? Senator from Douglas, Senator Francisco.
Thank you, Mr. President. I do have a comment, and it has to do directly with the question that Mr. Folsom was asked last year about can judges change the law? And I'm remembering his answer to be that it would take time because you would have to talk to the legislature. You would have to understand a concern that you've seen from your experience. You would have to present that, work with legislators, get their input, see different sides of it. So that's a very different understanding, but I did want to share that with this body because my understanding of his answer was not that you would do it. You can make change through case law, but if you want to change the law, you do that through the legislature. I think Mr. Folsom understood that. He certainly shared that with me. I have been impressed by the number of people who have had experience with Mr. Folsom and have felt that that was good, that he would be a strong addition to our court, and yes, he would add diversity. I believe more than ever we understand that seeing things from more than one point of view helps us get to a better decision in the end. I fully support this nomination.
Further question or comment? Senator from Johnson, Senator Gossage.
We have heard that he is a public defender. I met with Mr. Folsom today and had opportunity as part of the Judiciary Committee to listen to his testimony today and read through the volume of material that we were given about his background and how he answered the questions. I was appointed to the Kansas Board of Indigent Defense Services and understand that when he first put in his application, he was declined to serve. Then later, he brought that application back up and he was allowed to be part of that. He seems like a really nice man. Since that time, he has gone on. I understand that the current chair of that committee or that department speaks highly of him. So I just want to point out that this seems to be his greatest experience is as a public defender. I don't think anyone in this room would look down upon that. If anything, we would find that to be noble. But for this court, we would need to have somebody with a deeper breadth. We talk about the depth, but not the breadth. So I would concur with what Senator Warren has said about our concern about that. Thank you.
Further question or comment? Senator from Douglas, Senator Holland.
Thank you, Mr. President. I learned one thing early on in my life as a Democrat, that you save your bullets. So I really wasn't planning on getting him talking today about the nomination, but I do want to share a couple things. You know, typically since I'm, particularly on when I don't serve on a committee that is making recommendations for nominations or whatever, I really typically follow the recommendations of the committee and what comes out. And so, you know, when this nomination went down, I said, okay, maybe there's, who knows. But what really struck me is that when I actually left Topeka and got back into my business world, for those of you who don't know, I run a number of small businesses, and I very much believe in attorneys and being sure that whatever I'm doing with my business, that we're doing appropriately, adequately, and ethically. And I remember one of the firms that I use for my small business matters, this individual was flabbergasted that the legislature rejected Mr. Folsom's nomination. And this was a Republican attorney talking to me. The comments were made to me, Mr. Folsom is a walking Westlaw reference. Mr. Folsom, I could call him in the middle of the night with a particular question, and he could help me out. One other thing I want to share with the body, full disclosure here, Mr. Folsom grew up in Leavenworth County. He's a Tonganoxie kid. So darn right I'm going to go to bat for a Tonganoxie constituent, particularly when I think it appears to me that they are qualified for this position. And something I find interesting about Mr. Folsom's background is, once again, of that being a public defender. That's not a glamorous job. That's not a job you're making the big bucks. And I think that says something about the individual, particularly in the society that we live in today, of, you know, we look at the scales of justice. We want to be sure everybody's getting their fair shake. And so when his nomination was really coming up for consideration, that really intrigued me. I thought, you know, that is, I think, something special, is because you have a person who is potentially representing the dregs of society, the unfavorables, okay, the folks, you know, who other people, good people, don't want to hang around. But he's giving a voice to all in the court system. The other thing that really impressed me about Mr. Folsom is that, you know, when Tyson came into Tonganoxie in the middle of the night, and they tried setting up a chicken processing plant, Mr. Folsom was there with those citizens actively working to get that project shut down. And he was just working as a citizen. You know, it wasn't like he was professionally representing them, but he was there because he wanted, once again, citizens, folks, to have a voice, folks that aren't a powerful corporate interest. He wanted to be sure that their side was heard before those county commissioners, when they're making decisions to make that project go forward. So I stand here today. I'm not going to second guess the Judiciary Committee. I'm sure they have the reasons for what they want to do. But I just think when we look at Mr. Folsom's background, we have an individual, Mr. President, who brings a unique set of experience. He's not just another attorney. He's not just another litigator. He's not just somebody representing, you know, corporate or moneyed interest. He is truly a person who has represented folks in the lower echelon. And I hope we're not missing an opportunity here, Mr. President, to put that on, to bring that perspective into this opportunity. This is not about what this means to his career. This is about what it means to Kansas citizens as they work their way through the justice system. It will be interesting to see what he can bring. Thank you, Mr. President.
Senator from Johnson, Senator Corson, second time.
Thank you, Mr. President, and I'm going to do a better job of looking at you this time, so appreciate that. You know, I believe that the question that we should be asking ourselves as a body is not whether the hearing last summer was fair or not. I think that is immaterial and not really the question before us today, but rather the question is we are where we are. And based on the additional information that this body did not have, we now have the advantage of new information. I believe that myself as a legislator, I believe that other legislators, we are always trying to seek the benefit of new information. And we now have before us a very different flavor and understanding of the incredible background and experience that Mr. Folsom brings. We now have the letter from Stephen McAllister. We have the letter and the testimony from Jeff King. We have seen Justice Stiegel's op-ed. We've heard from 4 district attorneys about his immense qualifications. We've heard from the Kansas Bar about Mr. Folsom. All of that information we did not have in June. So I don't believe that the question should be whether or not the previous proceeding was fair, but whether or not based on all of this rich information that we now have, whether this nominee is now qualified. You know, the question was raised about why Mr. Folsom wasn't nominated for a district court position. The reality is that based off his experience, he is a much better fit for an appellate judge position, and that's why I believe he has appropriately been nominated for a seat on the Court of Appeals as opposed to a trial court position. He's litigated almost 200 appeals. He's argued 21 times before the Kansas Supreme Court, 46 times before the Kansas Court of Appeals, and 11 times before the U.S. Court of Appeals for the 10th Circuit. He is a natural fit for the appellate bench. He also, again, to the questions about the breadth of his experience, I would again remind this body that 75 to 80% of the cases that are going to come before the Court of Appeals every single year are criminal cases. So having that depth of experience with 80% of the subject matter that is going to come before the court, especially when there is such a current lack of that experience, would really make that court a much stronger court. And finally, again, I would just make the point of, I would encourage every member of this body to think about whether if a very, very well-credentialed assistant U.S. attorney came before this body, if a very, very well-credentialed district attorney came before this body, if a very, very well-credentialed county attorney came before this body, we would in fact be raising the same questions that we're raising about Mr. Folsom, especially if that prosecutor had letters of support from people like Stephen McAllister, from Senator Jeff King. We understand that Justice Stiegel obviously cannot endorse or oppose a nominee, but we understand his feelings from fellow district attorneys, from the Bar Association. I would just challenge this body, would we be having the same conversation if a prosecutor of the exact same experience with the exact same support was before this body? Thank you, Mr. President.
Further question or comment? Seeing none, Majority Leader, you may make the motion.
Thank you, Mr. President. After that robust discussion, I move the appointment.
We will hold for final action. We are now ready for final action. On this roll call, we take the appointment of Carl Folsom. Clerk will read the name.
Judge, Kansas Court of Appeals, Carl Folsom.
Clerk will call the roll.
Alley. Baumgardner. Billinger. Bowers. Clays. Orson. Dietrich. Dahl. Erickson. Estes. Bag. Valscudo. Francisco. Gossage. Haley. Bach. Hildebrand, Holland, Holscher, Kirshen, Cluse, Longbine, Masterson, McGinn, Olson, O'Shea, Peck, Peterson, Petty, Pittman, Pyle, Steffen, Straub, Solentrop, Sykes, Thompson, Tyson, Ware, Warren, Wilborn.
Has every senator had an opportunity to vote? Senator from Sedgwick, Senator McGinn. Has every senator had an opportunity to vote at this time? Does any senator wish to explain their vote? Does any senator wish to change their vote? Senator from Sherman, Senator Billinger.
Last aye.
Seeing no further changes, clerk will close the roll, tally the vote. Senator from Johnson, do you have a question? It takes unanimous consent for that because I closed the roll. Does anyone object to the senator from Johnson explaining her vote? Seeing none, you may explain your vote.
Thank you, Mr. President. We had the opportunity to appoint a man of integrity and enormously qualified attorney to the bench today. We had the opportunity to choose courage over comfort and appoint someone with a unique, valuable perspective to serve on our appellate court. It is disappointing that this body considers the execution of our Constitution to be too unsavory a duty for a well-respected attorney to serve as a judge. It is damning that participation in a constitutionally guaranteed due process is considered radical activism by some in this chamber. In not confirming Carl Folsom for the second time today, we have failed Kansans and our Constitution. And I would like my remarks spread on the journal.
So ordered. 18 having voted in favor, 17 against, the appointment failing to receive the required constitutional majority is hereby declared not confirmed. Consideration of appointments. Chair recognizes the Majority Leader from Sedgwick, Senator Solentrop.
Thank you, Mr. President. The appointment of Amy Klein to the Kansas Court of Appeals is ready for consideration.
Are there questions? Seeing none, Senator, you may make your motion. Oh, Senator from Douglas. Thank you, Senator from Sedgwick, for the little shout out. Senator from Douglas, Senator Francisco.
Thank you, Mr. President. I have a question for the senator from Cherokee, if he would stand for it.
Senator, you may choose to stand or not to stand. He's choosing not to stand. Do you have a question for the Majority Leader?
I can understand that. My question was whether those same questions had been asked of this nominee. Thank you.
Further question or comment? Seeing none, Majority Leader, you may make the motion.
Thank you, Mr. President. I move the appointment be confirmed, I move the appointment to confirm as a recommendation by the Committee on Judiciary.
We will hold for final action. We are now ready for final action. On this roll call, we will take the appointment of Amy Klein. Clerk will call the roll.
Judge, Kansas Court of Appeals, Amy Klein.
Call the roll.
Alley. Baumgardner. Billinger. Bowers. Clays. Corson. Dietrich. Dahl. Erickson. Estes. Fag. Vascadeau. Francisco. Gossage. Haley. Hawk. Hildebrand. Holland. Fulcher. Kirshen. Cluse. Longbine. Masterson. McGinn. Olson. O'Shea. Peck. Peterson. Petty. Pittman. Pyle. Steffen. Straub. Solentrop. Sykes. Thompson. Tyson. Ware. Warren. Wilborn.
Has every senator had an opportunity to vote? Does any senator wish to explain their vote? Does any senator wish to change their vote? Senator from Douglas.
Thank you, Mr. President. Passed to aye.
Any additional changes of vote? Seeing none, clerk will close the roll, tally the vote. "37 having voted in favor and none against the appointment of Amy Klein. This appointment, having received its constitutional majority, is hereby declared confirmed. Introductions of bills and concurrent resolutions. Clerk will read.
Senate Bill 37 by Committee on Insurance, an act concerning insurance. Senate Bill 38 by Committee on Agriculture and Natural Resources, an act concerning agriculture. Senate Bill 39 by Committee on Agriculture and Natural Resources, an act concerning agriculture. Senate Bill 40 by Committee on Agriculture and Natural Resources, an act concerning agriculture. Senate Bill 41 by Committee on Federal and State Affairs, an act concerning insurance. Senate Bill 42 by Committee on Federal and State Affairs, an act concerning the Department of Health and Environment. Senate Bill 43 by Committee on Education, an act concerning post-secondary education. Senate Bill 44 by Committee on Education, an act concerning the State Treasurer. Senate Bill 45 by Senator Holland, an act concerning property taxation. Senate Bill 46 by Committee on Assessment and Taxation, an act concerning income taxation. Senate Bill 47 by Committee on Assessment and Taxation, an act concerning income taxation. Senate Bill 48 by Senator Sykes, an act concerning insurance. Senate Bill 49 by Committee on Assessment and Taxation, an act concerning income taxation. Senate Bill 50 by Committee on Assessment and Taxation, an act concerning taxation. Senate Bill 51 by Committee on Education, an act concerning the State Department of Education and the Department for Children and Families. Senate Bill 52 by Committee on Ways and Means, an act establishing the Sedgwick County Urban Area Nuisance Abatement Act. Senate Bill 53 by Committee on Ways and Means, an act concerning charter commissions. Senate Bill 54 by Committee on Ways and Means, an act concerning civil actions. Senate Bill 55 by Committee on Education, an act concerning the healing arts. Senate Bill 56 by Committee on Judiciary, an act concerning human trafficking. Senate Bill 57 by Committee on Judiciary, an act concerning criminal procedure. Senate Bill 58 by Committee on Judiciary, an act concerning liens or claims against real or personal property. Senate Bill 59 by Committee on Judiciary, an act concerning crimes, punishment, and criminal procedure.
This constitutes introduction of SB 37 through SB 59. Announcements. Senator from Sedgwick, Senator Peterson.
Thank you, Mr. President. Senate Transportation will be meeting tomorrow and Monday in our regular room. Watch your emails for your WebEx links. Thank you.
Senator from Cloud, Senator Bowers.
Thank you, Mr. President. On your desk is an invitation to our Kansas Civility Workshop on Kansas Day, the 29th. And it's a work on civil discourse. It's a virtual event, and we're hoping you'll join us. Great presentations and opportunity to get to know other legislators and learn why civil discourse is important to our work. Thank you.
Senator from Lynn, Senator Tyson.
Thank you, Mr. President. I would like to clarify, when the senator spoke of Tyson, he was not speaking of this senator. This senator's not chicken. So, thank you. I would also like to announce that the Tax Committee had a hearing scheduled for Senate Bill 23. Today it was postponed until February 2nd. And I would like to draw everybody's attention on the ks.legislature.org website. If you're looking at the committees, you will not find the attachments for the committees under agendas, minutes, or testimony. The testimony will be found under the miscellaneous and early release testimony of files. Somehow it's been confusing to individuals, so I just wanted to clarify that. Thank you, Mr. President.
Senator from Sedgwick, Senator Kirshen.
Thank you, Mr. President. I wanted to announce that Agriculture and Natural Resources will not meet tomorrow morning, and we will not meet Monday morning, but we will begin hearings again on Tuesday, Wednesday, and Thursday of next week.
Thanks, Senator from Finity, Senator Dahl.
Thank you, Mr. President. I have a bill that I'm looking for co-signers, if you're co-sponsors, if you're interested. It pertains to medical marijuana. I have it here on my desk.
Senator from Leavenworth, Senator Pittman.
Thank you, Mr. President. The Democrats will be caucusing at 1 o'clock on Monday in room 287 North and via Zoom, unless otherwise notified. Thank you, Mr. President.
Senator from Cali, Senator Alley.
Thank you, Mr. President. Fed and State will not meet tomorrow or Monday.
Senator from Cherokee, Senator Hildebrand.
Thank you, Mr. President. I just wanted to make sure the body knew or is aware, and that the Senate Public Health and Welfare Committee caught the announcement today in committee that we are having another joint session with the House Public Health and Welfare Committee with KDHE over the COVID vaccination issues. And this will just be a continuation of the meeting that we had this last Tuesday. It'll be from 12 to 1 in the 112 North.
Senator from Johnson, Senator Thompson.
Thank you, Mr. President. Senate Utilities Committee will not meet tomorrow or on Monday, but we will have a hearing on Senate Bill 24 on Tuesday and Wednesday, and probably complete that work on Thursday. Thank you, Mr. President.
Senator from Sherman, Senator Billinger.
Thank you, Mr. President. Senate Ways and Means will not meet Friday or Monday. We'll meet next week. Thank you.
Senator from McPherson, Senator Wilburn.
Thank you, Mr. President. Just to further remind folks that the order for your Senate pins, the drop dead date is next week, 27th. So stop by my office. Darren will help you out. Thanks.
Senator from Lyons, Senator Longbine.
Thank you, Mr. President. The Financial Institutions and Insurance Committee will not meet on Friday or Monday. We will meet on Tuesday to hear Senate Bill 29 and Senate Bill 30.
Senator from Johnson, Senator Olson.
Thank you, Mr. President. Senate Commerce Committee will not meet on Friday or Monday, but will meet Tuesday, Wednesday, and Thursday next week. Normal room, normal time. Thank you.
Senator from Johnson, Senator Warren.
Thank you, Mr. President. Senate Judiciary Committee will not meet tomorrow or Monday, but we will be meeting at a regular time Tuesday, Wednesday, and Thursday, and we'll be working 3 bills Tuesday and 3 bills Wednesday. So be ready. Thank you.
Further announcements? I think we had more announcements than we didn't to this. Senator from Sedgwick, Majority Leader Solentraub.
Thank you, Mr. President. I move the Senate adjourn pro forma until 8:30 a.m. on Friday, January 22nd, 2021.
You've heard the motion. All those in favor say aye. Opposed, nay. Senate's adjourned.